welcome back. So we are moving on. This week, we are going to talk about public order offenses first, and then we'll finish up the week talking about morality crimes. So we're going to start with the offenses against public order. So let me share my PowerPoint. Hopefully you can see it. So that is what we're going to talk about. This was just a little quote from Blackstone. Remember that Blackstone was the one from England who took all of the common laws and brought them over to this country, and then they became our law. So the individuals of the state, like members of a well-governed family, are bound to conform their general behavior to the rules of propriety, good neighborhood, and good manners, and indecent, industrious, and inoffensive. So that's basically what we're going to talk about today. We're going to talk about these offenses against public order. Okay, so my first question then is, what is a public order crime? So when you think about public order crimes, what do you think that means? What do you think that actually includes? What would be an example of a public order crime? Well, we are going to refer to them as any of the offenses that disturb or invade the peace or the tranquility of society. So public order crime is a crime that disturbs public order, right? That we want to live in an organized society, structured, calm, peaceful society. And crimes that disturb that are what we consider public order offenses. So a couple that fall into that category or different types of crimes are what we call disorderly conduct crimes, which we'll talk about. And then we'll talk about what we call the quality of life crimes. Okay. So when we talk about disorderly conduct, it's usually something that is disturbing the peace. So a lot of times you may have heard of the crime disturbing the peace. That's basically what we classify as disorderly conduct. So fighting in public, unreasonable noise, abusive language, hazardous or offensive conditions, disturbing or an unlawful meeting. Disturbing a lawful meeting, failing to obey a police officer, obstructing traffic. So you're basically interfering or disturbing the general order of things. So that's disorderly conduct. So what is a possible problem with these crimes? If you think all the way back to the very beginning of the year, we talked about the idea of vagueness. One of the issues that often comes up when we talk about public order offenses is the idea that they can be vague. Remember, our laws have to clearly state what you can and cannot do, and clearly provide punishments for what you can and cannot do. Sometimes these laws are very general and they don't really define offensive behavior. They'll just say something that's offensive or something like that, and they're too vague. So sometimes you have them challenged on the grounds of vagueness. Another issue is a lot of times they don't have a level of mens rea, or at least knowing or reckless, but it doesn't include negligence. So this also can be problematic. We need to make sure that we know the proper mens rea. And should we be charging people criminally for negligence? And if it is just negligence, then maybe we shouldn't have charges in the first place. So those are some potential problems with these crimes. Now, when we're talking about disorderly conduct by a group of people, it can fall into three different categories. You can break it down into three different categories depending on what the activity is. So the first one would be what we would classify as unlawful assembly. So if a group of people all get together and they don't have the proper permits and they're protesting or something like that, just the fact that they're gathering without the proper permits can be labeled as an unlawful assembly, and it can be a crime. Now, if that unlawful assembly starts to engage in criminal activity, like property crimes or anything like that, then it is now referred to as a rout. If that unlawful assembly then starts to engage in violent acts, then it is classified as a riot. So depending on what happens with that group, it could be a lower level unlawful assembly, and it could raise all the way into a violent riot. So that's how we determine the difference between them. So what do you think of each of these? So a large noisy crowd is at an intersection in the city. Police arrive. We're dispersing the crowd when a man shouts from the doorway of a bar, refusing to obey the police request to go into the bar. So when we think about that, which one of that would be? Would it be an unlawful assembly? Would it be a rout? Or would it be a riot? So they arrive, they're dispersing, they tell the man to go in a bar, and he's screaming that he refuses to obey the police order. That may be a rout because you're not listening to the police and you're not following what the police are telling you to do. Police enter the bar and engage a tug of war with the man. The barmaid screams obscene marks, and they prevent the police from arresting the man. Again, now we're getting into criminal behavior. So since there is some criminal behavior, now this may actually be a rout. Okay, also, the first one maybe is just an assembly because you're not dispersing. Maybe the second one is a little further along because there's more of a struggle. So maybe that's more of the rout. And then the last one, the police are able to pull the man from the patrons, but one of the patrons hits the police officer in the head with a beer bottle. Now you're talking riot. Okay, so those are kind of the distinctions between the three. So those are what we call disorderly conduct types of public order crimes. We also have what we call quality of life crimes. Quality of life crimes are basically crimes that we call bad manners. Okay, we all want to live at a certain level, a certain standard, certain structure. And when people are rude and disrespectful and just don't do those kind of things, they're just crimes of bad manners in public. And that's what follows under quality of life crimes. So my question is, why would we even have these crimes? Obviously, they're going to be very low-level crimes, not that serious crimes. Why would we bother with these low-level quality of life crimes? Well, a lot of it is based on this idea of the broken windows theory. The broken windows theory, remember, says if you live in a bad neighborhood, run down, broken windows, awful, then it is more likely to lead to more crime in that neighborhood. So the quality of life crimes were established so that we maintain a certain level in a community so it doesn't evolve into a worse and worse neighborhood, which could lead to worse and worse crimes. So that is kind of what the basis is. Now, what are some of these quality of life offenses? Well, there's three that kind of fall into the category of vagrancy. Vagrancy is kind of hanging around, no really purposeful thing to do. You don't have a job. Loitering also falls in that category a lot. Most vagrant and loitering crimes have been found to be vague and unconstitutional because they'll just say no hanging around. Well, what does that really mean? With no means of employment, like what does that actually mean? So the Supreme Court actually overturned a vagrancy law and said it was too vague. So it's really hard to have vagrancy and loitering crimes right now because a lot of them have been declared unconstitutional. Another quality of life crime that you see sometimes is panhandling. So this is begging in the streets. New York City tried to pass a law banning all panhandling. And this, again, was all challenged all the way to the Supreme Court. And the Supreme Court said you have a constitutional right to be on the street and things like that. So as long as it's done in a peaceful way, you're not disturbing the peace, people are allowed to beg. So a lot of these public order crimes have been ultimately overturned as unconstitutional. Now, sometimes we have loitering with groups of people or gangs, right? So loitering of gangs or youth is often a problem, obviously, with the whole issue of gangs. So different criminal laws have been passed to try to limit the loitering of youth. So what they've done is they made it a crime to be part of a gang, extra punishment if you commit a crime as a gang member. It's a crime to encourage others to become a part of a gang member, punish parents if the child is part of a gang, crimes to loiter in groups. Again, a lot of these have been declared unconstitutional. We do want to stop gang activity. We want to limit gang activity, but the problem is a lot of these crimes are vague and they don't define what's illegal very well. The other thing is they're overbroad. They infringe on our right to assembly. And so therefore, a lot of these have been declared unconstitutional. Another category of public order offenses are what we call nuisances. Nuisances are activities that could endanger or be offensive to life or health. So a lot of times they could be really loud noises, they could be really bad smells. So sometimes you see neighborhoods where the grass is overgrown in a house and they're not taking care of it, and it's encouraging little rats and things like that to live there, and they're going into other people's yards. Those would be what we would call nuisances. So you can seek from the government what we call abatement for these types of public order nuisances. What you do is you go to the court and you have the court, or you ask the court to issue an abatement, which orders the person to stop this behavior. And if they don't, then it turns into disobeying a court order. So sometimes you have these public order crimes along the lines of nuisances. Another category that falls under nuisances is traffic violations. So we haven't really talked a lot about those. We're not going to get into them extensively. We don't have the vehicle and traffic law. It's a separate law in New York State. But most of these are strict liability offenses. There's no mens rea. It's like if you're speeding, then you get a ticket. They don't care if you intended to speed or anything like that. And then they're usually lighter penalties and fines. So again, a lot of these public order offenses, unless they lead to violence like a riot or something like that, are relatively minor offenses with very light penalties or fines or something like that. Now, another category that falls under this are different weapons offenses. So we have lots of different crimes for weapons. Generally, they fall into certain categories. So you could have certain crimes that deal with underage possession. So there could be age limits of when you can have a weapon. Unregistered weapons, you have to register weapons. That could be a weapons crime. Where the weapon is allowed to be located. Are you allowed to have it concealed or not concealed? Are you allowed to have it in cars or not in cars? And then transportation or possession of weapons for uses of crime. So there are all a huge variety of different laws that exist out there dealing with weapons. Now, we know, according to the Supreme Court, that people do have a constitutional right to possess a weapon. So the first time the issue came up was the District of Columbia versus Heller, and they overturned a ban on guns. And then McDonnell versus City of Chicago actually came out and said the Second Amendment does expressly give people the right to possess weapons. Now, that doesn't mean it's unlimited. None of your constitutional rights are unlimited, just like free speech isn't unlimited. So there can be some restrictions on the right to own guns, but you do ultimately have the right. So you have a variety of laws that can restrict it, but those laws are going to constantly be reviewed by the Supreme Court to make sure they don't go too far and violate your Second Amendment rights. Now, just some additional public order crimes and what we call them in New York. We do have a loitering crime. It's still on the books. We have unlawful assembly. We have inciting a riot or rioting. So we do have specific crimes for rioting. We have false reporting an incident. So if you lie about a crime that didn't actually occur. We do have many subsections to disorderly conduct. So you'd have to read through New York's disorderly conduct and see all the subsections. And we do have criminal nuisance. So those are kind of the names of the different public order crimes we have in New York. Now, the last category of public order crimes that I want to talk about are the drug and alcohol offenses. So we often lump these into public order crimes, and we're going to talk about them separate. So first we'll talk about the drug offenses, and then we'll look more into alcohol offenses. So just to get thinking about it, there was once a quote by Ralph Nader that said, addiction should never be treated as a crime. It has to be treated as a health problem. We do not send alcoholics to jail in this country. Over 500 people are in jail who are nonviolent drug users. So there's constantly the issue of whether or not actual drug use itself should be a crime, or drug possession by itself should be a crime. And that's some of the things you have to think about. Now, when you're talking about drug and alcohol offenses, the first thing you have to understand is the distinction between a drug and a controlled substance. So a drug is anything that causes psychological or physical response in your body. So it could be lots of different things. It causes something to in your brain to happen, or causes a physical response. So lots of things are drugs. Caffeine is drugs, nicotine is drugs, but it doesn't mean that they're necessarily illegal. There is a category of drugs, though, that are called controlled substances. So we consider some drugs so they can have such an effect that we require the government to regulate them. So if there are specific rules regulating the drugs, that is when they are called controlled substances. So remember, a drug is anything that has an effect on your body, but a controlled substance is something that the law is specifically regulating. Now, the laws dealing with drugs have sort of evolved over the years. There's been many, many different things. The first time you had any sort of anti-drug law was in 1906. Then eventually, and then you had the Harrison Narcotics Act. Most of these were just like a tax. It wasn't banning them or making them illegal to possess. It was just a tax if you possessed them. We started to see then eventually turn into being illegal to possess. The Marijuana Tax Act was again a tax, but by the 1951 Boggs Act, we started to then have some limitations on actual controlled substances. What was happening then is more and more people were starting to use drugs. It was causing a bigger impact on society. You had things being written in books. You had a lot of very famous people dying of drug overdoses. And this increased attention in the media and society and things on society, increased awareness. And it pushed the government to further regulate these controlled substances. What it did is it led to the anti-drug legislation, which became known as the Controlled Substance Act. So it's the Comprehensive Drug Abuse Prevention and Control Act. It's now been shortened to just be called the Controlled Substance Act. So if you hear Controlled Substance Act, this is the law that governs all controlled substances. Basically, what it does is it takes all controlled substances and breaks them into 5 schedules. The schedules are based on 2 things, the likelihood of addiction and the effects on your body. So if it's severe effects on your body and severe addiction problems, and possible medical use. So those are the factors we're going to look at. Does it have a psychological addiction? Does it have a physical effect on your body? And what is the medical uses, known medical uses for it? So Schedule 1 are controlled substances that have 0 medical uses. We've determined that they have 0 medical uses, and they have a very high risk of addiction and physical reaction of your body. So if you are considered a controlled one, if it's considered a controlled one substance, there are very, very rigid rules on it. People cannot possess it at all. The only reason to have it would be if you were doing some testing in a laboratory where you have to have a special license. It has to be specially locked up. It has to have severe controls on it. Then we have Schedule 2, which is our derivatives of Schedule 1. So they're not as potent as Schedule 1. They're still super, super strong, but there are some limited medical uses. So under the federal rules, marijuana is a Schedule 1 drug. But and like heroin and cocaine and things like that. But then we have derivatives of those. So you may have codeine, which is a medicine that is going to be Schedule 2. It's a derivative of it. It has parts of the Schedule 1, but a little less. So there are some medical uses, even though it's still highly, highly addictive and has a significant impact on your body. And then they just decrease down to Schedule 5, which is more the over-the-counter types of drugs, not really a lot of physical response, not a lot of addiction, not a lot of controls, okay? Now, so that is a federal law. So then eventually you have all these states that were creating their own drug laws, and they didn't always follow the they didn't always follow the federal rules. So eventually the federal government passed what's called the Uniform Controlled Substance Act. And what this act did is it required states to follow exactly the Controlled Substance Act. So it didn't allow states to have different rules than the federal government. The idea is drugs are easily transported, they cross state lines a lot. So the federal government has ultimate control over these controlled substances. And the Uniform Controlled Substance Act requires all states to follow these same Controlled Substance Act rules. Some other different drug offenses, you could have just mere possession offenses. You could have increased crime for sales. You could have different drug conspiracies. You have transportation of drugs. You have drug paraphernalia. So there's a lot of separate or different drug offenses that fall into these categories. Now, when you talk about drug offenses, you have to think like a prosecutor. What are the different requirements that we have to prove these crimes? So one of the big issues is possession, right? So we've talked about before when we talked about actus reus that there's different types of possession. There's actual possession when I actually have it in my hand. And then you have constructive possession, meaning that you have control over it, even though you aren't physically controlling it right at that minute. So that's one of the issues is actual or constructive possession. And if it's constructive possession, you actually have to show knowing possession, right? That the person actually knew they were in possession of it. So one of the things you always have to remember as a prosecution, if you choose a drug offense, is showing possession, either actual or constructive, and also showing that it was knowing. Another big issue when you're talking about drug crimes is the amount of controlled substances that the person has in their possession. This often affects the degree of the crime that you're charged with. So if you're in possession of a small or trace amount, it's going to be a lesser degree. If you're found in possession of a large quantity of a controlled substance, obviously that's a higher degree. And on top of that, they can add charges. If you are in possession of a large amount, you can be charged with intent to sell or distribute. So that is the issue. The idea is you only have that large quantity, not for your own use, but because you are going to distribute it to other people or sell it. So sometimes large quantities adds additional charges for these different things. Now, when we look in New York, we would want to look at how New York defines controlled substance. So when you look up controlled substance in New York law, you will see that it directs you to the public health law. So our penal law, our laws dealing with controlled substances are actually governed by the public health law. And you'll see if you look at different degrees in New York that there's different amounts and things like that, but it's all based on the definition of controlled substance. And basically New York follows the exact definitions that the federal government follows. So those schedules that are created in the Federal Controlled Substance Act are the same schedules that we follow in New York. Now, there are just a couple other issues I want to point out. Police pull over a car that is driving erratically. When the driver approaches the car, it appears the driver is high. He asks the passenger or driver to step out of the car. He then searches the passenger compartment and finds a marijuana joint in the cup holder. According to the penal law, what is the presumption made about every person in a car when controlled substance is found? So one of the things we said is you have to show knowing possession or you have to show knowing possession, right? So what if you're in a car and in the cup holder, there's marijuana? Is every single person in that car in knowing possession of that marijuana? So the specific section 220.25 specifically says there is a presumption that all people in the vehicle have knowing possession of the controlled substance. So what this is saying is instead of the prosecutor having to show that the passenger had knowing possession, it's automatically told to the jury that if you're in a car and it's in a place where everybody can see, then it is automatically knowing possession. It then takes the burden off of the prosecutor and puts it on the defense to prove no, in fact, you did not have knowing possession. So that is one of the issues with this law. It switches burdens of proof. So no longer does the prosecutor have to prove it, because it's automatically presumed and told the jury that everybody there is in possession of, knowing possession of that marijuana. So same scenario, but when they search the passenger compartment, they find marijuana in the passenger's pocket. So it's not in the cup holder in like an open space, it's in the passenger's pocket. So now when we look at 220.25, what is the presumption made about everyone in the car about that controlled substance? Well, if you look at that section again very carefully, there is an exception. It says if the controlled substance is concealed on a person of one of the occupants, then therefore that presumption goes away. So if it's in an open area, the burden switches to the defendant to prove they did not have knowing possession. But if it's in a concealed location where people could not have seen it or known that it was there, then that exception goes away and the burden switches back to the prosecutor to prove knowing possession. What about this? Police respond to a call by neighbors of a loud party. When the police arrive, they knock on the door and are allowed to enter the house. When inside, police notice 5 people sitting in the family room, and on the coffee table, they see cocaine. According to 220.25, what is the presumption made of all people in close proximity to that controlled substance? So the prior example was in a vehicle. This is in a house. And if you look at 220.25, it's the same thing. There's an automatic presumption that anybody in close proximity is in knowing possession of that controlled substance. So same concept. Open area, everybody's around, anybody in close proximity is going to be in possession. And the burden switches to the defense to prove they did not have knowing possession. What about this? Police arrive at a hotel where management reported a disorderly conduct and drug use. Outside the hotel, the police observe Henry standing by a tree with a matchbox on the ground about 18 inches from his feet. Inside, the matchbox contains PCP. Police place Henry under arrest and charge him with possession of controlled substance. So this is a little different. He's out in a public place. He's just standing out in the public. It's not in his actual possession. It's just on the ground. What is the presumption? Do you think the prosecutor can establish that Henry possessed PCP? So if we look at that section again, if there is an exception, if it's a public place. So the first example was in a house. This is just outside in a public place. It's harder to show that it was actually Henry's. It could have been just sitting on the floor in the ground from somebody before, and Henry just walked by. So that is an exception. Then we're going to switch the burden back to the prosecutor in those cases. So I know it gets confusing, but it's all talking about who has to prove knowing possession. Is it already a presumption? Are you going to tell the jury it's already shown? Or are we going to switch it and the defense has to prove they didn't knowingly possess? Or is the prosecutor actually going to have to prove knowing possession? Okay, so the last thing I want to talk about are some other drug issues, other issues with drug and alcohol. One of the big things that we often see is this crack cocaine disparity. When the laws were originally written, so hopefully you understand crack is a version of cocaine. They're basically derived from the same thing. Cocaine was very expensive. Crack was a cheap version. When they wrote the laws, what was happening is if you were in possession of a certain amount of cocaine, it was a lower offense than if you were in possession of the same amount of crack, even though they were derived from the same. What it led to is a lot of racial disparity because crack was a cheaper version, so it ended up being a version that was used in more lower economic areas. different minority groups had better access to it. And it led to a huge disparity in who was going to jail. So if you were rich and you could afford cocaine, you wouldn't get arrested and go to jail. But if you were poor and used crack, you would get very, very long sentences, sometimes even life sentences. So it led to a huge disparity in minorities being sent to jail for drug offenses. They have recently tried very, very hard to change this disparity and change, because they're the same thing. So you do see a lot of push to change that disparity. Another issue when you're talking about drug and alcohol offenses is asset forfeiture. If you are in possession of something that is used during drug trades, drug sales, or you have a lot of possessions that are obtained because of drug sales, the government is allowed to take those resources and you forfeit them. So if you have a lot of cars and property and things like that, and you cannot show how you lawfully earned the money to buy those, and the police can show that you probably used drug money to buy them, the government is allowed to take them. Another time where you have asset forfeiture is if you're driving a car or something and you're selling the controlled substances out of the car, they're going to take that car. It is somewhat controversial because it can sometimes be argued that it's double jeopardy. You're going to go to jail for it. And then to take your property on top of it is double jeopardy. For the most part, though, the courts have upheld asset forfeiture. And then the departments turn around and sell it and keep the money. We talked about marijuana, and we talked about the Controlled Substance Act as a federal law and that states were supposed to follow it. What started to happen, though, is many states have started to legalize marijuana, even though the federal law still makes it a Schedule I offense. There was a court case, Gonzalez, that specifically said Congress has the right to regulate marijuana any way they want. Okay, and they can make it a Schedule I if they want to make it a Schedule I, and the states should follow that. But the states have gone against that, and the states have legalized marijuana. New York is legalizing marijuana. So there has been a big question on what is the federal government going to do about it. So far, the federal government has not done anything. They have said, okay, states, even though there's a Uniform Controlled Substance Act, we'll let you get away with this as long as we're not seeing big problems crossing state lines into other states that maybe still have it illegal. So right now, states are going against the Uniform Controlled Substance Act, and the federal government has just made a conscious choice not to do it. But if they chose to, they may have strong legal grounds to make states outlaw or make marijuana illegal again if they choose to. Obviously, prescription abuse is a huge issue. A lot of the addiction issues we've seen come from being addicted to pain meds, and then they can no longer get the pain meds because they're Schedule II drugs and you have limited access to them. And then people are turning more towards the more street drugs. So that has been a significant issue. In the past, we were really tough on crime. We had a war on crime. So we had very strict mandatory sentencing. We had strict plea bargaining rules for any drug offenses. Again, this led to huge disparity in sentencing of minority groups. So we've seen a backlash against that. We've seen a lot of sentencing reforms, and we've seen less harsher sentences for drug possession. Okay, so the last thing I want to switch to are consumption of alcohol offenses. So those were mostly the drug offenses. Let's just spend a few seconds talking about alcohol offenses. So we have so obviously alcohol is legal under certain conditions, but if you are under a certain age, it is not legal. So the main offenses are dealing with the age of who is having it, what the person's doing if they drink too much, and then also driving offenses. So some of the current consumption alcohol offenses is consumption of alcohol by minors. In New York, we call it minors in possession. If somebody is under the age of 21 and consuming alcohol or in possession of alcohol, that is a crime. It is also a crime to buy or purchase alcohol for the purpose of giving it to somebody under the age of 21. So that falls under endangering the welfare of a minor. So we see certain offenses that fall under that category. And sometimes we have offenses for public drunkenness or disorderly intoxication. Generally, it's not a crime itself to be drunk, but if you are drunk and doing something that causes disorderly conduct, that can rise to the level of a crime. Now, we also have, so in New York, we don't actually have a public drunkenness statute. If you are drunk, you have to do something additional, and it just falls under disorderly conduct. We do, however, have a separate crime for appearance in public under the influence of a narcotic or drug other than alcohol. Okay, so if you look this up, we actually have a specific crime for being in public under the influence of drugs. So you can find that in the penal law. But remember, alcohol falls under disorderly conduct. Other drugs would fall under this section. And then we have obviously DWI statutes. So these are driving while under the influence of alcohol or drugs. Now, this is not in the penal law. So if you're looking for it in the penal law, it's not there. This is actually included in the New York Vehicle and Traffic Law. It's section 1192 of the Vehicle and Traffic Law. What this law says is obviously it's illegal to operate a motor vehicle in New York on a public highway, private road open to motor vehicle traffic and parking lots if the operator is intoxicated. So there's always questions, what's operating a motor vehicle? If you are sitting in your car and if you're in the driver's seat, even if the keys are not turned on yet, it is presumed that you are operating the motor vehicle. So if you're in the front seat and you fall asleep, even if you're not driving, they can presume that you are operating a motor vehicle. Now, it has to be on a public highway, but it also can include public roads if the private roads, if the private road allows the public to drive on it, and parking lots. So just being in a parking lot, sitting in the driver's seat, even before you move, can qualify as a DUI, driving while intoxicated, or DUI, driving under the influence. And then you have to be intoxicated. So we have to think about, how do we prove intoxication? Well, we have to show a high blood alcohol content. So what is blood alcohol content? It is the percentage of alcohol compared to the amount of blood you have in your body. And so we can measure that in different ways. So they can obviously do a blood test and actually very scientifically measure how much alcohol you have in your system. But they can also use sobriety tests. So walking straight lines, saying the alphabet, touching your nose, they check your eyes. All of those have been scientifically linked to activities of your brain. And if your brain is impaired by a level of alcohol, it can't do those activities. So they can estimate your BAC based on your responses to those field sobriety tests. And the courts have upheld those. So you are not allowed to operate a motor vehicle in New York with alcohol. And depending on how much alcohol you have will affect which your charges would be. Now, we also have in New York something that's called a refusal to submit. In New York, driving is a privilege. It's a privilege to drive a car. You don't have a right to have a license. So what happens if you're pulled over and you refuse to submit to a field sobriety test? Well, we have failure to submit consequences. If you refuse to submit, they can automatically take your license away since it's just a privilege. So when you get your license, you are agreeing to submit to field sobriety tests. And if you refuse, then they can revoke your license. Some states have taken it to the next level and actually made it a crime for refusing to submit. And has gone to the Supreme Court, and the Supreme Court has upheld refusal to submit as a crime. Okay, so that's all the notes I have. So just to get you thinking, late one night, a deputy sheriff found Ronald Rico in his car parked on the side of the road in a rural area. He was at the wheel, the headlights were on, the radio was playing, the motor was not running, No one else was in the vehicle. A field sobriety test showed that Rico had a 0.14 blood alcohol concentration. So looking back at the requirements for DWI in New York, could you prove each of the elements under the circumstances if you were the prosecutor? And what defenses could Rico's attorney likely raise? So hopefully you can look back through your elements, think through, would you be able to show each of the 3 requirements for DWI in New York? Okay, so that's it. That's all I have for this week or for this lecture. And then the next one, we're going to talk about morality offenses. See you soon.